Just heard the end of the testimony from the firearms expert called by the state talking about projectiles. I'll bring in my guest in just a moment, but just a reminder, he asked the jury, did they have any questions? The response was no. In the state of Florida, the jurors can ask questions of the witness. They did not have any in this particular instance. I want to bring back in my former prosecutors, current criminal defense attorneys, Melanie Ellwanger and Kirby Clements. Thanks again for being here. Let's jump right in. You know, the first thing I said, let's talk about, because the exhibit pictures are hard to see, so we weren't showing them of the projectiles that this witness is testifying with. What are projectiles? Kirby, let's start with that.
Projectiles are the portion of, you take the bullet as a whole piece. The projectile is that piece that comes flying out of the barrel that strikes the body, or that's the part that comes out. That's just the technical name, projectile, but it's just the front end of the bullet that comes flying out.
All right, so he's testifying as to those pieces that come flying out in this crime scene. So we know that the mother was shot with a gun 8 times, and we know that one of the children was shot. So in looking at these projectiles, what is the main goal in your experience, Melanie? Are they trying to identify what type of gun was used?
I think that is exactly what they're trying to do. What kind of gun it was, and is it the same gun? And I think that's why they're talking about the caliber, about the pieces that they found around the room, and the medical examiner talked about the pieces in the body. But to show that it all came from the same gun, that hurts the defense's theory of multiple assailants.
Yeah, that's a great point. So he testified it could be a .32 caliber revolver. Now we talked about, you know, I'm from Texas, I know how to hunt, but I don't know all the handguns. And I said to Kirby, hey, you know, is this the type of gun anybody could have? And you made the point, well, anybody can get any kind of gun anymore, right? Like that's not
right.
that. So what does it mean that it's .32 caliber revolver? Does that say anything significant to you?
Well, .32 caliber, first of all, in terms of the firepower of that gun, it used to be used for protection, but now you've got 9mm and much bigger projectile or bullet, you know, shooting guns, which are more devastating. But in the context of .32 caliber, it helps to narrow it down, because all the possible guns out there, we now have a .32 caliber. And then we look and determine, was it an automatic or whether it was a revolver, and we narrow it down again. So now we know it was one firearm, and then if there's any connection to the defendant, you know, at a .32 caliber, we can say he owns a .32 caliber.
Okay, I'm going to pause you right there, only because something is going on in the courtroom. We're going to go right back to see.
And Your Honor, with all honesty, if Mr. Santos is testifying, there's going to be a lot more involved by the state.
Well, I know we're getting in a posture. You're leaving no time for the penalty phase. If we're going to have a penalty phase, we have to have it done. We can't get into the Thanksgiving week. We've told them we weren't going to be here then. So we can't keep losing time here. It's what you're telling me. We're losing time. We're going to put it into a scheduling problem.
I think that last time we discussed that the death penalty part would only take, I think, a full day of what we discussed last time. So I still think we're in a posture to finish up by that Friday with the death penalty included.
Every time we lose time, we put it further back. So,
like I said, I'm doing my best to make sure
right.
it is. We were anticipating finishing on
Right.
Wednesday anyway, Wednesday morning as it is. We had some hopes about possibly Tuesday, but in projecting out, we were already talking about Wednesday.
I don't remember saying that I was okay with Mr. Knox testifying on Monday. I'm thinking that's not real likely to work. So, what's his problem again?
He's teaching a class every day next week.
Well, I mean, we're here trying a first-degree murder case. You know, he may have to miss a class. That's not acceptable. Just to kick it over to another week just so he can teach a class. That's not acceptable. We're going to need to keep it going. So, you know, don't suggest to him that we're going to do that. I don't know. We'll see, but we need to. We can't keep killing time. All right, we'll take 5 minutes.
Thank you.
All right, so you just heard the judge say, and I'll tell you what, I am a judge, and it's really hard sometimes to maintain your courtroom and make certain that you follow the schedule, stick to the schedule, finish the trial, and also that you make sure that you give the attorneys an opportunity to present everything they want to present. But basically, he said, we are at risk of going too long. If we waste time, every time we waste time, it's bad, and we're not going to keep wasting time. And a witness apparently had a class they had to teach, and he said, well, too bad. This is a first-degree murder charge, which I cannot disagree with. Now, when we come back, we're going to have more coverage of the death penalty trial of Florida versus Henry Segura. Stay with us. And there's a new Court TV podcast out today you're not going to want to miss. This week, Vinny and Seema look at the Ezra McCandless verdict. Now, they're going to break down the defendant's testimony, how her story changed, and point out where she may have gone wrong.
Her story evolved. Like, she had memories that somehow didn't come out.
They were like locked in a box.
They were locked in a
You
box.
need a key to open it.
Yeah, and the key
Nobody
is
had the key.
The key is a murder trial, and then now you've got to change your story. Here's the problem that I have with her and a lot of other criminal defendants at trial is that their memories change and evolve. But every they change and evolve, the memories get better for their defendant and worse for the prosecution.
Isn't that convenient?
Every single time. I want one of these repressed memories to come back that actually, oh my goodness, that makes me look more guilty.
You can listen to the latest episode on Stitcher or Apple and Google Podcasts, and you can always find it on CourtTV.com. We're going to be right back after this short break.
This is the kind of card that has America talking. With it, people with Medicare are getting all-in-one coverage for their doctor visits, hospital care, prescription drugs, and more. This kind of insurance, called Medicare Part C, may also cover dental care, eyeglasses, hearing aids, fitness programs, vitamins, even healthy meals and rides to the doctor. With this kind of coverage, you do not need a Medicare supplement insurance plan. You will access your benefits through your Medicare Part C plan for one low and oftentimes $0 monthly plan premium. You deserve to get the most from your Medicare benefits. Call now for free information that may help you get more coverage for less money. There is no obligation to enroll. Whether for yourself or someone you love, call the number on the screen now. Call now.
If you've been injured in an accident that wasn't your fault, and you're struggling to pay your bills while your case is dragging on, that's where Oasis Financial comes in. Only Oasis has Oasis Express Cash that can get you from $500 to $25,000 in as little as 24 hours, faster than anyone else. There's no risk and no out-of-pocket cost.
It was so simple. I made one phone call. Oasis was able to give me the money within 24 hours.
To pay for my electric bill, my rent, and my groceries for my children.
And even if you end up losing your case, Oasis lets you keep the money. So there's absolutely no risk to you. You don't have to worry about repaying Oasis.
If I had lost my case, then I wouldn't be responsible for paying the money back. And that was a blessing.
Oasis, they killed it, man. They helped me out. They gave me my life back.
See how much money you can get before your case settles. Call Oasis Financial, because life moves faster than your case. 1-800-605-4381. 1-800-605-4381.
We received this today.
It looks like some sort of ransom note.
And look how much they're asking for.
Ma'am, this is a cable bill.
Fed up with high TV prices? Get Orbi TV. Quality satellite TV for just $40 a month. With no contract or credit check. All taxes are included, so the $40 package is just $40.
This looks like a classic shakedown.
Available at Best Buy or go to orbitv.com for more information.
I have hair, but after I pay for car insurance, I'm too broke to get a haircut. What are you giving up to pay for car insurance? Save money with Good to Go Auto Insurance. Get started with as little as $20 down, then pay monthly. It's cheaper because you buy just what you need to be legal. Check it out. Visit goodtogo.com and get a rate quote in under a minute. Then let your hair down and get back to what you've been missing. Visit goodtogo.com. It's fast, cheap, and easy. Visit goodtogo.com. That's good, the number 2, go.com.
This is Kate.
Hey.
She takes 2 prescriptions. Kate's son Jack takes one too. Kate works hard and thought she had good insurance, but she still pays too much. That's no good. So Kate downloaded the GoodRx app. Now she can compare prescription prices to find the best discounts. She even beats her insurance price. Good for you, Kate. Good for you. GoodRx. Stop paying too much for your prescriptions. Download the free app today.
Welcome back to Court TV, your front row seat to justice. We are continuing our live coverage, and this is Florida versus Henry Segura. And right now, the court is on a break for technological, I just had my own, issues. They're working that out. We hope that they'll be back in court anytime. In the meantime, I want to bring my special guest back in. We have Kirby and Melanie, 2 former prosecutors, now defense attorneys. And here's one of the questions that was put out there that I want to ask what you think. So we know that there is DNA from other individuals on the scene. Specifically this morning, we learned through testimony that under the fingernails, there was some female DNA. And could it be that this defendant maybe planned this or was involved in planning and someone else was the assailant? Let me start with you, Kirby. Does that seem like a possible theory to you based on the evidence we know of?
Well, I think the prosecution can certainly make that as a theory, that he planned it and he set everything up. But that just seems to be a level of planning that's on the level of movie producer planning. I'm gonna need you to get scratched so we can get DNA under your fingers. I'm gonna need you to leave footprints over here so we can get that done. I mean, it's a theory, but it's not gonna carry any weight. I think it's just a matter of that's a problem for the state.
All right. And Melanie, do you think it's a problem for a defense that they say, well, this was a mob hit, and we have over 200 witnesses on our witness list and over 35 expert witnesses on our witness list, but that they can't produce a person who they say did this?
Do I think that's a problem for the defense?
Sure.
I do. Yeah. I mean, because when I heard defense opening argument this morning, I loved it. It's one of the best opening arguments I've heard. What a great story. If this plays out the way they say it did, not guilty all day long. But, and again, we'll have to see what the defense is able to produce, but 100% you need to put another person there beside the defendant. We know he was there. Mm-hmm. We know he was there. He said he was there. His DNA is there. You got to have somebody else in the house. They need that evidence.
Right. Now, I don't disagree. And so, the other part of this that I really struggle with is 9 years ago, the investigators did their investigation. We know there are multiple footprints in the blood around the body inside the door where Brandy, the victim, was shot. We know that there's blood spatter. We know that the children were in a bathtub at a different location in the house. What we can't do is necessarily reproduce the investigation from 9 years ago. Mm-hmm. So maybe things were missed. Maybe things weren't done that weren't the norm in terms of forensic evidence or investigations that now 9 years later we would do. Kirby, does that affect the case?
I think it does affect the case. And even though it was 9 years ago, it's not like we were in the Stone Age. I mean, 9 years ago, you could still say there are several footprints. How do we explain that? When was she being killed relative to these people being drowned? Was that the same person? Why did no one flee? Those questions existed then, and they perhaps should have been followed up on then. And the evidence was gathered, so they should have done something to investigate that more now with the new technology to say, we've checked it out and it gives us the answer, he did it, or we checked it out and it tells us nothing. But they can do something. So I think it helps the defense in this situation.
And I know the defense has, and I know we read about it and talked about it a little bit earlier today, and that is the defense had that opportunity of 9 years and even made a motion at one point to go to Italy to test some individuals to see if it matched DNA and they were involved in the cartel or the mob. So I would think the 9-year delay has really helped the defense. What do you think in terms of getting additional evidence to put on the strong argument that this was a mob hit?
That is a really good point, because sometimes when you're rushed into trial, you might miss things. And so now that they've had this time, and extra DNA evidence, look, as a defense attorney, extra time is never a bad thing for me. In this case, we may have too much time because he's been sitting in custody for 8 years. I'm not sure what exactly made this case take so long, but yes, extra time never hurts. I think the defense was probably pretty thankful for that.
All right, so Santos, this is a big wild card we know in terms of this case, but if he testifies, and he is the one, just a reminder as we talk through this case, he's the one that says, this was a hired hit that I did, right? I hired this, and she was skimming money or drugs off the top of the cartel, and so this is the problem that I had with her, and that's why I ordered the hit on the family. If he testifies and does what he was going to do last trial, which is take Fifth Amendment, protect himself from self-incrimination, I don't think it's going to help the case at all. If he actually testifies and takes the Fifth Amendment again, then that doesn't help anybody.
Right, and I think he's going to be limited as to what he says, because if he's going to take the Fifth as to ordering the hit, then they're not going to be able to bring that statement in anyway. But if he's made it, they might try to introduce it as a prior inconsistent statement and say, well, this is what he's not talking to us now, but we want to put it in as a prior inconsistent statement. Although that's a misnomer, which is a prior statement that he refuses to acknowledge that he made before. But it doesn't necessarily help it helps the defense, but I'll say this. It's not the defense's burden to prove who killed him. It's just their job to say the state has failed to prove that the defendant killed them. And that's the only issue. So all of these questions, the more that there are, the better for the defense.
Yeah, and I do think juries sometimes, obviously, human nature, you want to know who did it, right? You want an alternative theory pointing the finger at a person, but I know in cases that I'm involved in and listening to, that's a rarity, right? If you had that, then the state's not usually going to proceed with trial in the first place because there's somebody else that they may be able to say, oh, they actually did it. So a jury just hearing, oh, this mob person did it, it was a mob hit, what does that do to how they're deliberating a case?
I think it opens the door for reasonable doubt and that someone else did it. I don't necessarily have a problem with the defense calling him and him taking the Fifth because it makes it look like he has something to hide. So I don't think it's terrible. I think the jury can infer that he has something to hide. He doesn't want to incriminate himself. So I think either way, put him on the stand, hopefully for the defense he admits, because I've heard that he wrote letters to the judge saying, this time I really do want to testify. So maybe he will. So maybe, but either way, let's get him on the stand, see what he does if I'm the defense attorney, absolutely.
Right. And it's going to be interesting to see. So the rumor is, yes, what we want to do is go ahead and let him testify, but that he probably is going to take the Fifth. I mean, that's what we've heard and what we expect in this case. So another part of this that we've talked about just briefly, I think it's a real risk, but it was a strategic decision. This defendant waived his right to a 12-member jury, rather asked for a 6-member jury, so there's 6 jury members. What do you think? A risk or not, Kirby?
I think that's a huge risk. I'm one that doesn't believe in giving up anything. I want 12 people up there because if 11 to go against me, there's that one that'll go for me. It's a gamble. I see why he did it, but I'm not that big of a gambling man.
That's right. Reasonable doubt. One person with reasonable doubt. Now, so Melanie, when they did that, we know 2017, the acquittal, it was 8-4, 8 in favor of acquitting, in the mistrial. So does that number that 8 were for acquittal, 4 were for guilty when they had to declare that mistrial affect whether or not you would say, yeah, let's go with 6 jurors this time?
It had to in the defense's mind. They're thinking we got 8 the first time. Maybe we can get all 6 this time. But like Kirby was saying, the issue is then you have less people to be your holdout for reasonable doubt if everyone then, because again, first time 4 people wanted to convict. You've got 6 this time. I don't know, but I definitely think that they're just playing a numbers game and it may be a risk.
And I think, too, we have to keep in mind it's the defendant's choice ultimately, so the lawyers can advise and say, here's some strategy, and we don't think you should go with 6. Then the defendant might say, I'm going with 6. I heard 8-4. I want to go with 6. And if the defendant does that, are you obligated to then say, okay, we're going to do a 6-person jury?
You're absolutely obligated. There's nothing like having that conversation with your client and saying, this is literally the dumbest thing I've ever heard come out of a human being's mouth, but I will do it because you said we should do it. Or you withdraw. And nobody's getting to withdraw in this case, so you got to roll with it.
Yeah, so stay with us. We're going to continue to break down this case. Court is still on break. We're going to take that opportunity for a very short break. When we come back, we will have more live coverage of the death penalty trial of Florida versus Henry Segura. Stay with us.
Tonight on Court TV.
We're live in Tallahassee for the family massacre murder trial. Prosecutors are attempting to prove Henry Segura killed his ex and 3 children over unpaid child support, while the defense is trying to prove that this quadruple homicide was orchestrated by a drug cartel. Only Court TV will keep you updated on every twist and turn in this case.
Closing Arguments with Vinnie Politan. Tonight, starting at 6/5 Central on the all-new Court TV.
Best Fiends. Meet Hank and Roger, the not-so-dynamic duo. Join the adventure. Collect tons of cute characters and solve thousands of fun puzzles. Download free today. That's friends without the R. Best Fiends.
This is the kind of card that has America talking. With it, people with Medicare are getting all-in-one coverage for their doctor visits, hospital care, prescription drugs, and more. This kind of insurance, called Medicare Part C, may also cover dental care, eyeglasses, hearing aids, fitness programs, vitamins, even healthy meals and rides to the doctor. With this kind of coverage, you do not need a Medicare supplement insurance plan. You will access your benefits through your Medicare Part C plan for one low and oftentimes $0 monthly plan premium. You deserve to get the most from your Medicare benefits. Call now for free information that may help you get more coverage for less money. There is no obligation to enroll. Whether for yourself or someone you love, call the number on the screen now. Call now.
Attention! The Centers for Medicare and Medicaid Services has officially authorized new benefits that Medicare Advantage plans may include. To get the benefits you deserve, you can call the Medicare Coverage Helpline.
Hi, I'm Joe Namath. If you're on Medicare, this is important information. I called the Medicare Coverage Helpline and they instantly looked up my coverage. In this one simple call, they offered to enroll me in a plan that includes rides to medical appointments, private home aides, doctors and nurses' visits by telephone, and even home-delivered meals. The plan also includes dental, vision, hearing, and prescription drug coverage, all at no additional cost.
Don't delay. Call to see if the new benefits are available in your area.
Call the number on your screen now. It's free.
Call 1-800-497-5903. That's 1-800-497-5903 now.
If you've been injured in an accident that wasn't your fault, and you're struggling to pay your bills while your case is dragging on, that's where Oasis Financial comes in. Only Oasis has Oasis Express Cash that can get you from $500 to $25,000 in as little as 24 hours, faster than anyone else. There's no risk and no out-of-pocket cost.
It was so simple. I made one phone call. Oasis was able to give me the money within 24 hours.
To pay for my electric bill, my rent, and my groceries for my children.
And even if you end up losing your case, Oasis lets you keep the money. So there's absolutely no risk to you. You don't have to worry about repaying Oasis.
If I had lost my case, then I wouldn't be responsible for paying the money back. And that was a blessing.
Oasis, they killed it, man. They helped me out. They gave me my life back.
See how much money you can get before your case settles. Call Oasis Financial because life moves faster than your case. 1-800-605-4381. 1-800-605-4381.
With the money I've made on Poshmark, I've been able to pay for all our family's vacations.
I could pay for my wedding just on what I've made from Poshmark.
I've made over $10,000 and I was able to buy my new car.
Download the free Poshmark app now.
Welcome back to Court TV. I'm Judge Ashley Wilcott. We are covering the case with 41-year-old Henry Segura charged with murdering his girlfriend, her twin daughters, and their 3-year-old son. Now, the state says his motive was money. They believe Segura killed his family so he could avoid paying back child support of over $20,000. Keep in mind, this is a retrial. Segura was on trial for 4 counts of murder in 2017. At that trial, the jury was hung and a mistrial was declared. Court is still on a break. They're trying to fix some technological issues, so that'll give us a chance to talk. Melanie Kirby still with me. Let's break it down a little more. We're going to listen to some of the testimony from Foggy, but again, I want to talk about the fact that there's no weapon that's been found. In spite of the victim, Brandy, the mother of the 3 children, having been shot, one of the 6-year-old children was shot in the head, but there's no weapon. What do you do with that as the prosecution or defense? Does it make a big difference, Kirby?
Well, from my prosecution days, I can just tell you, it doesn't make a difference. I just tell them, we don't always get the weapon, but is there any doubt that this person was shot? We don't need a gun to tell you that he did it. From the defense perspective, it's just one more piece of missing evidence and things that they didn't pull together, and had they done their job properly, they would have found the gun used by the real killers, not my client.
And we know that the defendant's 2 cars were searched, and there were some gloves and there were some other things that were found, but no gun. Melanie, what do you do with that?
If I'm the defense attorney, I love it. Again, this isn't some man that's a high-end criminal that planned this out. This is just a man, this is a dad. He didn't have the time to plan this out. So again, if there's no evidence in his vehicle, especially if there's no gun, I think it goes to reasonable doubt that he didn't do it. And in fact, someone else did it. Look at them and find their gun.
And I always think that gun is somewhere. It's one of those cases where who knows, in 20 years, somebody may find a gun and say, oh, it was found out in the woods or whatever, and then it gets linked back to the crime. Can't always happen. What I want to do now, though, is listen to some of the testimony from Foggy. Now, Mr. Foggy is the firearms expert called by the state a few minutes ago in court, talking about the caliber of gun.
Would it be normal in a situation for a projectile to simply bounce off a small piece of aluminum, such as this?
That would cause for me to speculate. It really depends on a lot of factors.
Okay. Well, one of those factors in this particular case, these projectiles you did, and ultimately we get to conclusion, but they were from a .32 caliber weapon, correct?
That's correct. The projectiles were .32 caliber.
What would be, as a .32 caliber weapon, is there some problematic issues with a .32 caliber that may cause it to bounce off a small piece of metal in firing a weapon?
I don't know that it would be problematic, but a .32 is not a very powerful round if that's what you're getting at. It's not as powerful, say, as a .45 or a 9mm or a .40.
So Jeff Foggy just said a .34 caliber is not a very powerful round. Why would a person use that if it's not a very powerful round, powerful gun?
Well, that's sort of the point, is that those guns were used to be in fashion for self-defense. It's an easily concealable gun because it's smaller. You can stick it in your pocket, stick it in, in your waistband. It's not going to pull your pants down or something like that. So that's why you might want to have it, and without thinking of its lethality, because most people who purchase guns, unless you're really into guns, you don't really think, will this kill? You just figure guns kill, I got a gun, I'm safe.
And that, to me, is part of the crux of the issue. You've got 8 shots. Melanie, I want to hear from you in a minute, but 8 shots, and it didn't kill her. And then it's a vicious beating by whoever shot her to then result in her death. So what are your thoughts?
And I think something interesting about this gun is you're right, it's not a self-defense weapon. And really, I think .32s these days, most people use them for rabbit hunting.
Wow.
Honestly, so I think it's bad for the defense because it goes to show you just use the gun that you have. And is the cartel using .32s? I wouldn't think, I'm no expert on the cartel, but I'm not thinking that they're using .32 caliber bullets on their hits.
Yeah, it's interesting. Let's listen to a little more testimony again from Jeff Foggy, the firearms expert called by the prosecution earlier today.